Alden.
Thanks, Jim. This morning I'm going to talk about customer contracts. Now, if you've been using the same contracts for the last 10 years, or even the last 3 or 4 years, the contract version you're using is probably illegal. Illegal meaning illegal under your licensing laws. You are a regulated industry. There are certain requirements and certain things that have to be in your customer contracts. And this isn't a joke. We spend a lot of time in our firm defending contractors on licensing enforcement actions before the Department of Labor and Industry. And for the Department of Labor and Industry, there isn't really a differentiation in the law for license violations. A simple violation of not having a certain piece of paper that you're required to have from the law side is as serious as committing a fraud from a dollar standpoint. Now, fraud may get your license revoked, where not having the piece of paper may only cost you $10,000, and that's $10,000. But it's very important. And so I'm not up here saying that this is something that you should have. These are things that you must have. And if you don't have them, customers will abuse you. They will find out, or they will know that you have to have these things. They'll go to a lawyer that is on the other side of these things that will tell them, and they'll threaten you. And they'll say, listen, you didn't do this right, and I'm going to turn you into the department, or basically you can walk away, you can buy my roof, and we'll just keep it quiet. I see that happening. Does that make it right? Does it make it fair? No, but it does happen. And the department, when they start looking at things, don't usually just look at the customer complaint file that made the complaint against you. They also look at all of the contracts you've done for the last 2 years. I see that kind of request regularly. Or they ask for all your subcontractor payments and things, and looking to see if you paid individuals and violated the ICEC law because they didn't have an independent contractor exemption certificate. So there are lots of different things that can trip you up. I'm not going to be talking about all of those things this morning. We don't have enough time. I'm going to be talking about the paperwork, the customer contracts. So with that, let's get started here. The overview here, we're going to talk about the contracts themselves. We're going to talk about all of the different disclosure requirements that you have to have. Those disclosure requirements are the formaldehyde notice. They are the statutory warranty. They are if you're doing insurance work, the disclosure that says that they have a 72-hour cancel notice. The 3-day right of rescission notice, we'll talk about that. And the performance standards requirement, which you have to give them a notice before you contract with them that says that you have performance standards and what those are. So you have about 5 different items that you have to give your customers in addition to your contract. And they generally have to be separate from the contract, so you can't put them in your contract document. They have to be provided with your contract document. After we talk about the disclosures and the required disclosures, we're going to talk a little bit about the no rebate deductible law. Now, Charlie Dernberger is going to be here today at noon, and he's going to be talking a lot more about that law, and he's going to be talking about it from the Department of Labor and Industry's perspective. So I'm not going to spend a ton of time on that, but I want to make you aware of it because it does affect your customer contracting. Then I'm going to end up with some best practices and wrap up. And then after I finish all of this relating to customer contracts, I have a little personal note to bring up to you as a member of the board of MNAES. So now I'll get started here. The first item here is the formaldehyde notice. And I've got the statutory site there. It's 325F.18. It applies whether it's residential or commercial. It applies when you have products that use formaldehyde in the treatment process. Now, historically, it's been green treat lumber where formaldehyde was used. And then I know they went away from that. I believe they went back to it. I'm a lawyer. I don't know what they presently are using. Maybe John over there from Allied, he might know. But in any event, why risk it? Because what you're going to have to do is you're either going to have to go and determine and verify that all of the materials that you use do not use formaldehyde, or just provide this simple disclosure. Why do you provide it? You provide it because Minnesota law requires it. If you don't provide it and you have used materials that have formaldehyde in them, you can get sued, and it's considered a deceptive practice. Now that's a big deal because when it's a deceptive practice, they can get attorney's fees and costs under the private attorney general statute. So you're going to end up paying their lawyer and paying their damages. all because you didn't provide a piece of paper when it's required. Again, it's only required when you have materials that you're using that have formaldehyde used in the manufacturing. But why worry about it? Just provide the disclosure. So a takeaway on this, give the disclosure, reference it in your contract. It's not usually, it's good enough to give it to them from a law standpoint, but people are going to not remember that you gave it to them when you're in a dispute with them. If you have a reference in your contract, your lawyer can pull that out and show it to them on the stand and say, listen, it says right here on this contract that you got it, so you did get it, didn't you? And as a lawyer who litigates, we don't care what the answer is, because we can abuse them either way, which is what lawyers do with witnesses on the stand. If they say they didn't read the contract, we can go down that road. If they say they did read the contract, and we say, well, you didn't speak up then when you didn't get it, even though the contract says you did get it. So either way, reference it in your contract so that you have it quite clear that they've acknowledged that they've received it. The damages, as I mentioned, can be quite severe. It's just not just the personal injury damage, it's the attorney's fees that go along with it. So provide the disclosure. Now the statutory warranty, it used to be an implied warranty. This is 327A, the 1-2-10 warranty, 1-year workmanship, 2-year mechanical systems, 10-year structural. You never used to have to inform your customers that they had this warranty. It was implied in every contract that you had for residential construction. That law changed. That law changed a couple years ago. And then you now have to provide them a copy of the warranty itself in the statute. Now there's a little bit of a debate about whether you had to provide them the entire statute or whether you had to provide them just the section in the statute that has the warranty in it. I've always had customers in my firm, contractors, provide the entire statute. And with some more recent changes to that statute, I think that's the best practice. I think also the statute calls for you to provide the entire statute, because at the end of the statute, it talks about the warranty provided by the entire statute. Now, why is that a big deal? Because if you provide the entire statute, it's probably going to be about 5 pages. Maybe you can fit it on 2 pages front and back. Maybe it's going to go on to 3 pages. So it's going to be 3 or 5 sheets of paper in addition to your contract that you're going to have to give your customers. And so we get resistance. People don't like providing all that extra paper. But as far as I'm concerned, provide the entire statute. Don't just provide the subdivision that gives the warranty itself. The statute, if you don't provide it, it's a license violation. And so if you haven't for the last 2 years been giving this statute out with your contracts, and the labor and industry comes back and asks for the information from you in a licensing action, you're going to have a violation here. There's not much you can do about it going backwards. Just hope that you don't have the customer complaints, because most of the labor and industry licensing actions are generated from customer complaints. And so if you do have this sort of Achilles heel out there, just recognize that you have it. But going forward, make sure you change your practice and you provide the statute along with your contract. And again, reference it in your contract that they've been provided this, because people, again, have selective memory. I didn't get it. I hear that all the time in litigation. And if you have multiple reference points that say that they did get it, you can use that against them on the stand. Now, because this warranty is provided by the general contractor to the customer on a residential contract, that doesn't mean that your subs are providing this warranty as well. There is no law requiring subcontractors to provide a warranty to you. So what you should do is you should pick up this warranty in a written subcontract agreement between you and your subs and push that liability down on your subs, because if it's their mistake, if they forget to put ice and water shield down and it costs you money, it should be their responsibility, both legally, contractually, to fix that. And if you're going to get sued on the warranty, you should be able to turn to them under your agreement and say that they're also providing you the same warranty, and go after your subs for the cost that it cost you on that. So if you're not using written subcontract agreements, do so. And do so, this is just one of the many reasons why you should be using them, so that you can shift that liability risk where it belongs on your subs who did the work. You need to look at your existing contracts and make sure that you're doing these things. You're providing that formaldehyde notice, that you're providing this 1-2-10 warranty in writing. Now is a good time to review your contract anyway, because as one of the handouts that we have out at the table out there, and Charlie Dernberger will be speaking on later today, your license numbers have changed. Everyone should have gotten a letter on that from the department. And because your license numbers have changed, you're going to have to change that number on your contracts. So it's a really good time to be looking at all the other things you may need to change on your contracts to be compliant. And the items that we're going through here this morning are most of those items that you legally have to have with your contract. Now there's a lot of other things that are a good idea, and I'll be covering those at the end. But these items you have to have. The home solicitation notice is the one that, for those of you in the room that have been contracting for a long time, that's that 3-day right from signing, that when you go and knock on their door, they have 3 days to cancel their contract. That actually changed in 2005 and 2006. There's a couple of cases that came down that said that when it's an improvement to real property, you don't need to provide this 3-day right of rescission. Now this is going to get confusing because we're going to have another new rescission right that we're going to talk about later relating to residential insurance paid roofing and siding contracts. But this is the old law. Now why do I bring this up? Because a lot of contracting attorneys have told their clients that they don't have to provide this anymore because of this Bush v. Modell case. And that's not necessarily true. And why it's not true is, let's say you were going to go out and fix an ice dam. That's not an improvement to real property. You have somebody sign a contract for that. Well, if you solicited that sale through a home solicitation sale under the statute, you do have to give the right of 3-day right of rescission for that. Let's say you go out and do repair work, like a patch-in. That's not an improvement to real property. That's repair. And if it's repair work, you also, again, if it was a home solicitation sale, have to provide that 3-day right of rescission under Minnesota law. When you're required to provide the 3-day right of rescission and fail to do so, your contract's invalid. Now, the statute does say that you can get your stuff back, but you tell me how you're going to tear a roof off and not do damage to that property. You're going to get sued if you try to get that stuff off. And by the way, you have to trespass on their property to get it off. So you're going to get sued for that as well. So in your industry, how the heck are you going to get your stuff back? You're not. And so it's a big deal under this statute. It's not just that you're out of pocket. You're out of pocket the material. You're not going to get the job bought. You're going to end up buying it yourself, all because you didn't give a 3-day right of rescission notice when you should have. Now, Charlie will probably be speaking about this at noon, but he told me that the Commissioner of Labor and Industry, this next legislative session, is going to be pushing for a change in the law to have this a requirement for your contracts. So the law used to be that you had to provide it. Then it got unclear. Then it got to be where the court said, no, you don't have to provide it when it's an improvement to real property. Now we're going to go back to where you have to provide it. So again, this being a good time to fix your contracts because your license numbers changed, I would suggest or encourage all of you to provide this 3-day right of rescission. Now this right you can use as a sales tool. Because when your sales reps are out there and somebody had a hail loss and they're at the home, you can say, listen, this is not a hard sell. We're a reputable company. If you feel at all uncomfortable about what we did here today in signing this agreement, you can cancel it. You have 3 days to cancel. So you can use it as a sales tool to make the customer feel comfortable. And frankly, if somebody's going to want to cancel a contract within 3 days of signing it, do you really want that job? Because that might be a problem customer. Clearly the relationship that you thought was established really wasn't established. So bottom line is, the law right now, in some circumstances you have to provide it. In some circumstances you don't have to provide it. However, the law is going to change. And I can guarantee you that some sales rep of yours is going to fail to provide it when they're required to provide it. And it's going to cost you money. Now, this isn't the only law. There are related laws. The FTC, federal, has a rule that says you have to provide them a 3-day right to cancel. That's what this is. This would be compliant under the FTC rule. Now, luckily for you, under the FTC rule, There's no private right of enforcement. So the FTC or the federal government, U.S. attorney, would have to come after you on that rule. And they have other fish to fry. So I don't expect that they're going to be coming after you under the FTC rule. But it is a rule, it is law, and it does require a 3-day right of rescission. And there are no ifs, ands, or buts on that one. The state of California and the American Bar Association have also interpreted the Truth in Lending Act that if you're trying to enforce lien rights, you're extending credit. And if you're extending credit under the Truth in Lending Act, you have to give a 3-day right of rescission. Or if you actually do extend credit. So if you give them 6 months to pay, or you have one of these financing arms that you work with that finances the project, and I know a lot of contractors do that, under the Truth in Lending Act, which is a federal law, you have to give them a 3-day right to cancel. The Minnesota version is Truth in Lending Act compliant, which means you can solve the problem with all of these laws by just providing the Minnesota version of the 3-day cancel notice. Now that's the cancellation 3 days from them signing the contract. The next one that we'll talk about is the insurance cancel notice. That's the newer law. And that really applies to residential exterior roofing and siding jobs. It used to just be roofing, but they modified it, and now it's roofing and siding. You guys, what you do. And it says that you have to give them a notice that says that they have a right. And the right is that if their insurer denies their claim, they have 72 hours from that insurer denial to cancel, and you have to give them a form, actually a duplicate, to send back to you, one of those two, to cancel the contract. Now, that's the same kind of thing as that 3-day right of rescission that we just talked about. You have to give them a form in duplicate that says that they have a right to cancel the contract. So it gets confusing because you're going to have to give them actually 4 more pieces of paper. 2 notices for the home solicitation rule, and 2 notices under this insurance cancellation rule. But that's not it either. The insurance cancellation rule also says you have to give them a notice that they have this right. So it's kind of like the Army. You have to tell them what you're going to tell them, then you tell them, and then you tell them what you told them afterwards. You're going to have to do that as well in this circumstance, where you have to give them a piece of paper that says that they have this right. And that has to be separate from your contract. So you're going to have a 5th piece of paper. Then you also want to reference both of those rights in your contract. Under the home solicitation rule, you have to reference it in your contract. And there's some magic words that you can use there right out of the statute. And it has to be in proximity to the signatures, their signatures, your customer's signatures on the contract. So putting it on the back side isn't good enough. You have to put it by their signatures, telling them that they have that right under the home solicitation cancellation. On this right, you have to give them a separate notice that says they have it. And again, like I mentioned before, put it in your contract that says that you gave them that notice, that they have that right, because they're going to forget about it when it's time for a dispute. So there's a 5th piece of paper that you have to give them. 2 notices of cancellation on one statute, 2 notices of cancellation on the other statute, plus a notice that they have the right to cancel. I don't hear any groans yet, but I should be hearing groans. So 5 pieces of paper on the statutory warranty. Formaldehyde notice, that's a 6th piece of paper, and then another 5 pieces of paper, so we're up to about 11 pieces of paper now, in addition to your contract. Now, this law wasn't well drafted. And so what happens if you don't give them the notice? This is now the 72-hour notice to cancel. The law is not clear. Under the 3-day right of rescission, the home solicitation cancellation, the statute is clear. Your contract's no good. This statute doesn't say that, although it's a license violation if you don't give this to them, but it's unclear what the penalty is for failing to provide it. And again, this only applies to roofing and siding residential contracts. We'll talk about that a little bit more later when I'm done with this portion of my presentation. But the takeaway is, give them the notice that they have this right, the 72-hour cancel right from insurer denial. Reference it in your contract, and don't start work before the job's been approved. What's approval? That's another thing that's unclear in this statute. The statute says insurer denial of claim. Okay, well, we have lots of times where we have a partial approval. Is that a partial approval or is that a partial denial? Is that a denial or a claim? Or is that an approval of a claim? The statute doesn't specify. And so we don't know. I would think, And again, we don't have any case law. A judge is going to have to interpret this. Somebody's going to have to spend a lot of money with a lawyer to get the courts to interpret this. But we don't know what it means when you get a partial approval. I would suspect that the judge is going to be reasonable and say, well, that's an approval of the claim for the work that was done, as long as the work doesn't go outside of what was approved. But we don't know, and the statute's not clear. But we do know that if it's a full denial, this law kicks in and they have a right to cancel. Now, I know a lot of you in the room think, well, this is just ridiculous, because if the claim doesn't get approved, we're not doing the work anyway. That's your sales pitch. You're not going to be out of pocket anything except for your deductible, and we're not going to do the work, and this contract's not going to be